Hello, I'm Burrell, president of the Magic City Bar Association. Thank you so much for joining us for this final installment of our social distancing CLE series. This has been a great year for the Magic City Bar, and it's all because of committed members just like you. At the conclusion of the CLE, be sure to do 3 things. First, submit feedback so you can get credit for attending the CLE. Second, renew your membership. Third, send an email to 5 friends asking them to join or renew as well. Lastly, be sure to join us for our annual meeting later this afternoon so you can be in the know about what's going on with your organization. We will now turn it over to our CLE presenters. Happy holidays.
Good afternoon, everyone. I'm Terrell McCants with Burrell and McCants. I'm a partner here. I practice primarily civil rights law, including Section 1983 cases, as well as employment discrimination. If you hadn't noticed, Deandra is not here today. She is under the weather, so I will be handling the CLE in its entirety. I want to, if I can figure out the screen share, I'm going to put up the slides that Deandra actually did most of the work on, but I'm going to take, here we go. Okay, so this CLE is about litigating Section 1983 cases, or 1983 cases, and overcoming immunity challenges. So first, let's talk about what Section 1983 is. This is section, when we say Section 1983, is short for what you see at the top of the screen there, 42 USC Section 1983. It gives us in relevant part that every person who, under color of any statute or ordinance, regulation, custom, or usage of any state or territory of the District of Columbia, subjects or causes to be subjected, any citizen of the United States or other person within the jurisdiction, deprivation of any rights, privileges, immunity secured by the Constitution and laws. So anyone who acts under the color of state law to deprive someone, to deprive a citizen or anyone who is under the jurisdiction of the United States, to deprive them of their constitutional rights or rights given to them by the Constitution or federal statutes. It's important that we look at that these are rights secured by the Constitution and federal statutes, because state laws, violation of state laws would not get you to the level of a Section 1983 cause. Section 1983 is a federal cause. It gives you a federal cause of action for constitutional violations and violations of federal statutes. Just for example, I had a case years ago where the police officer made an arrest for a misdemeanor. The state procedural law in Alabama is that officers can't make misdemeanor arrests that were committed outside of their presence. That didn't serve to provide a sufficient constitutional basis to get you to sustain a Section 1983 claim. Further, under Section 1983, Congress didn't provide a statute of limitations for these claims. So the courts have taken that vacuum and filled it with state statute of limitations. And that is whatever state that you're in, your personal injury statute of limitations is what the statute of limitation would be for a violation that fell under Section 1983. So in Alabama, that's 2 years. Tennessee, if you're in Tennessee, we're talking 1 year. So we've talked about what it is, what Section 1983 is, but now let's talk about more practical things, the elements of your Section 1983 claim. If you see the top of the slide is don't wing it. You want to be very specific in how you lay out your Section 1983 claims. You want to know what the specifics are of your injury, of your client's injuries. If you are doing these cases, you want to make sure that the wrongdoer is acting under the color of state law. When I'm pursuing these cases, I sue police officers most of the time, police officers, prison guards, law enforcement officers, and correctional officers. So generally, I don't have an issue of whether they're acting under the color of state law. Those positions, them doing functions, performing functions inside of those roles and those offices generally automatically give you that under color of state law. But you want to make sure if you have any other situation that you have checked that box. Next is know the identity of the defendants. And that might sound very elementary and rudimentary, but in these particular cases, Section 1983 doesn't, it's not like other cases where you have respondeat superior that works automatically for you. If a Walmart employee injures you, you can generally sue Walmart for it. Something happens, you sue Walmart, you don't have to know the names of the individual employees or who is responsible for cleaning up a spill. If you got a slip and fall, you just sue Walmart and you're fine. You allege that an agent of Walmart didn't do their job. But Section 1983, you need the individual defendants. This comes up oftentimes because I'll tell you, my clients, and if you do this kind of work, you already know, most of the time, they don't know the officers' names, whether it be an excessive force case, whether it be a false arrest case. They're under a lot of stress once they make it to where they're needing a lawyer to address wrongdoing. They were under a lot of stress in the original situation, so they weren't keen on getting the names, getting badge numbers, getting car numbers. They know very little when they come to your office at first. Two, the officers don't usually formally introduce themselves. So, but I've seen at least one case where the entire case was lost because of an incorrect officer identification. So when you're suing officers, you want to make sure, you want to get the reports, first you want to get your case filed in time. Hopefully they came to you in a time that's well before the statute of limitations, so you can get your case filed and do any discovery that you need to find the officers if you don't have, if the client doesn't have that information readily available. Next, this is something that if you don't practice in federal court very often, which is where these cases 9 times out of 10 end up, because these are federal statutes, these federal question cases, You may say, well, okay, well, if I don't know the names of the defendants, I'll just fictitiously plead them. And that works in state court. You can, if you don't know everybody, you can say fictitious defendant A through Z that did X, Y, and Z to my client. Federal court generally doesn't allow fictitious pleading. So, but that's not a death knell to your case if you can't find the officers' names. You don't have it. Say you're coming up on the statute of limitations, and you're going to need to go ahead and get it filed. What I normally do in those cases is use a principle from a case from an 11th Circuit case called Dean versus Barber, which states that in federal court, though fictitious pleading is generally not allowed, you can, and this is going to sound it's going to sound like semantics a little, but you can plead a real party fictitiously. You can't fictitiously plead a party, and all that means is that if I know what the officer did, and I should know that from my client, I should know what date he did it on, I should know his or her gender, race, the location that it happened, the date, and all of these things. I have all of these descriptors, these multiple descriptors. I can name John Doe that did X, Y, and Z. It's kind of like fictitious pleading, but it's not saying there's somebody out there that may have done something and I want to name them, and I'll find out later whether they did something or not. I have a real person. The only thing I don't know about this person is their name. And I have generally been successful in arguing to the court because the defense will usually still make the argument that you're trying to do fictitious pleading. And I used that Dean versus Barber case, and we have very good success with it. Next on the list there is, have you pled a violation of a constitutional right? That is going to be crucial in Section 1983 cases. It has to be a constitutional right or a federal statute, but you can't be a state violation, can't be a state law violation. It has to be a constitutional right. So the 8th Amendment, have you pled an 8th Amendment violation? That's going to be cruel and unusual punishment. That's going to be when someone has already been convicted and they are in the punishment stage, something less. Usually that's an 8th Amendment case is going to be when someone happens to someone in prison. That's the usual setting for an 8th Amendment violation for cruel and unusual punishment. So you file, if an officer beats your client after they've been convicted, subjects them to any kind of torture in prison, whether you're talking about the denial of medical needs, deliberate indifference to serious medical needs, if it's post-conviction, you're going to be looking at the 8th Amendment. So that's what you would plead in 1983 would be your vehicle to bring your 8th Amendment violation in. The next one is the one that I mostly deal with, 4th Amendment violations. That's your right to be free from unreasonable searches and seizures. That also encompasses excessive force, as you can see there. So you have unlawful seizures where property is taken, unlawful arrest, your person is taken without probable cause or without arguable probable cause, and excessive force would also be deemed an unlawful seizure. So under the 4th Amendment, this is going to be a person that has not been convicted. Usually you're talking about someone that is in the process of being arrested, having some interaction with law enforcement outside of being detained, outside of being incarcerated in any form or fashion. Your 14th Amendment is going to be next. This one is common as well. So if you have someone that has been arrested, say someone is taken in and they're beaten by police officers at the jail. They're beaten with handcuffs on, they're tased, something has happened where they're being beaten, where there is no just cause for the officer to be using force upon them, but they have not been convicted yet. That person would be a pretrial detainee. A pretrial detainee he hasn't been convicted, so he has a right to due process before he's punished. And when law enforcement or correctional guards take it into their own hand to mete out punishment before the person has been convicted, and it is without proper cause, your client isn't resisting, isn't posing a threat to the officer or someone else, you're looking at a 14th Amendment violation. And these things they're important how you plead these, because it matters where you are on the spectrum as far as which amendment was actually violated. A pretrial detainee wouldn't be, you wouldn't go under Eighth Amendment because he has not been convicted. So we're not talking about cruel and unusual punishment. We're talking about punishment before the person is even eligible for any punishment. He hasn't been convicted of anything. He is presumed innocent at that juncture. Okay, so next we'll go to, and this is a little weird. I'm used to seeing people, but I'm seeing myself in my screen, so forgive me. What is immunity? So the part of this is overcoming challenges, immunity challenges. So the two types of immunity we'll discuss today will be absolute immunity and qualified immunity. We're going to talk mostly about qualified immunity just because it's the most common type of immunity you're going to face if you do this type of work. Absolute immunity kind of is what it is. Qualified immunity there's a lot more gray area to it. And pretty much every civil rights case that I've ever litigated, there's been a claim of qualified immunity used. So we're going to talk about that one most, but to get absolute immunity out of the way, because like I said, if you do this type of work, you're going to have clients that want to sue people that actually have this type of immunity. And absolute immunity belongs to judges, magistrates, prosecutors, and I say these with the caveat, these people have absolute immunity with the caveat that they have to be performing, if it's a judge, it has to be a judicial function. If it's a prosecutor, it has to be within their prosecutorial functions and discretion. And magistrates, the same thing. They're going to get immunity on, usually, if you're talking about a magistrate, you're talking about whether there was probable cause for a warrant to be issued, if a magistrate issues the warrant. So they're gonna usually all have absolute immunity. There's pretty much nothing you can do to get around that if they're operating within their roles. So that's a brick wall usually. But I have clients all the time that come and tell me, the judge did this, the prosecutor held this, and now I need to sue them. Let's go ahead and sue them, man. Hold your horses. There's a nice shield that protects them. So let's look at other avenues if you feel that you've been wronged. So to get into, to pivot from absolute immunity, qualified immunity is not such it's a wall, and it has turned out to be a wall since this case, the seminal case on qualified immunity from the Supreme Court is Harlow V Fitzgerald. It's a case from 1982. And this is the case that essentially formed the qualified immunity doctrine. The Supreme Court held that a public official, law enforcement, school officials, and other government entities performing discretionary function enjoys immunity in the civil action for damages provided his or her conduct does not violate clearly established statutory or constitutional rights of which a reasonable person would have known. So if you're talking about, and I know it gives law enforcement, school officials, and other government entities, I tend to talk about what I'm most familiar with. I usually deal with law enforcement. So my examples generally come from that arena. So if we're talking about a false arrest, the claim is that usually the client comes to me and says, they arrested me, I wasn't doing anything, I didn't do what they said I did. Well, the officer is not as cut and dry as, okay, if you didn't do it, let's sue them for a false arrest. Qualified immunity, that officer may be entitled to qualified immunity if he has arguable, and the 11th Circuit has said, he doesn't have to have clear probable cause, but even arguable probable cause to believe, to make an arrest for any offense. So if he makes an arrest, if he makes an arrest, and let's say he charges wrong, he charges incorrectly, and he charged you with something that was clearly off base, but you stood out there and screamed and cursed and caused a public nuisance, caused distraction to everyone out there in a public place. He may have charged you with something that wasn't related to disorderly conduct, but the officer can always go back and say, okay, well, I had arguable probable cause to get him on disorderly conduct, and one good charge will negate the bad charges, and he will get qualified immunity because he had arguable probable cause. And how you determine whether he had arguable probable cause is, would a reasonable officer, or could a reasonable officer in the same situation as the defendant officer make that same call? So if you have an officer that's making a decision, the supposed theory or rationale behind qualified immunity is that officers have to make split-second decisions. They have to, and once we get to look at it, once people, lawyers, anyone gets to look at it, we can look at it in hindsight and see that it was clearly an incorrect decision. But the courts will not allow the officer to be judged from hindsight, but he'll be judged from what a reasonable officer would have done in the situation with the information that he had. And if no reasonable officer would have done the same thing or could have done the same thing in the situation that officer did, now he has his right to qualified immunity may be stripped away. And excessive force, whether we're talking about under the Fourth Amendment for someone that's being arrested or being detained by officers, or whether they're talking about 14th Amendment for pretrial detainees, or 8th Amendment for convicted prisoners. It's the same standard. Would a reasonable officer believe that this level of force was necessary? Was the person posing a threat to the officer? Was the person posing a threat to someone else? Was the level of force needed to affect an arrest? Or, and there are a few other factors that I'll go into briefly. the relative size of the officer and the person, the skills of a person. I had a case once where fortunately for me, my client was 5'6" and about 140 pounds, and the officer was 6'8", about 370 pounds. And he thought that it was a good idea to put handcuffs on my client and tase him while he had handcuffs on in a puddle of water in a jail cell. And when I took his deposition, when I took the officer's deposition, I went over all of these standards of how you make a determination of whether force is necessary or unreasonable. And one of them was the relative size. And he thought that it was still okay for a 6'8", 370 pound officer to tase a person, a very small person, much smaller person in comparison, certainly, to tase him while he was defenseless in handcuffs. Thankfully for us, the judge disagreed with that officer. Okay, so that's qualified immunity. And I want to tell just if you're doing these kind of cases, you probably already know these things, but if you're interested in starting to do them, I had a situation where like I've heard people say, older folks say, the best sense sometimes is bought sense. Early on, I was doing these cases. I started doing these cases, and I had a gentleman out of Mobile. We were in the Middle District, and he owned a check cashing store there. So he owns a check cashing store there, and he says there's a ring of people that come through with fraudulent checks, with bad checks. They have copied they have copied checks and forged checks, payroll checks, and they have come through and cashed about $10,000 worth of checks, bad checks, against his business. So my guy, I'm not saying this was the approach that I would advise you to take, but he took this approach. I'm representing the store owner. He calls back. Has his clerk to call the ringleader back to the store because the ringleader was apparently sweet on the clerk, and she called him back saying she had car trouble, and my guy was lying in wait to come out and hold him there for the police. So the guy comes back, and my guy comes back out. My client comes back out, and he's holding him there at gunpoint, tells his clerk to call 911. And they come there, and the initial deputies that get there arrest the ringleader. They arrest him, put him in the police car. They search his car. They find more stolen checks. They find more fraudulent checks. They find credit cards, marijuana, all kinds of things in the ringleader's car. So if the story ended there, I would have never met my client. The story doesn't end there. When this detective, another deputy shows up, the detective shows up and finds out what's happening, gets the story, finds out that my client had held the guy there at gunpoint, and now he's about to be taken off to jail. She says, well, she goes and talks to the guy, and the guy says, well, yeah, he was holding me at gunpoint, asking me what I had done with his money. Well, the detective decides to release the ringleader and arrest my client for menacing. Then she later raised the charge to robbery. She said that he had robbed the ringleader. He was attempting to rob the ringleader. So we filed for false arrest, where the statute is clear that private persons have a right to make citizen's arrest or arrest by private person. So we file the case, and they file we do discovery, take depositions. They file a motion, the defense files a motion for summary judgment, saying that the officer had arguable probable cause to make the arrest for the charges that she had leveled upon my client. So the judge comes back, he rules, Southern District Judge, or she rules that, yeah, the officer had arguable probable cause to make the arrest, though it would have been clear to most people that he was affecting a citizen's arrest. She had arguable probable cause, and they initially did not charge him with robbery. They charged him, if you go back to what we were talking about earlier about state violations, she had charged him with misdemeanors initially, which were allegedly committed outside of her presence. So she shouldn't have made the arrest in the first place. But that wasn't a constitutional ground that we could stake our 1983 claim on. So we appealed it to the 11th Circuit, and the 11th Circuit actually affirmed the granting of summary judgment in that case. And what I learned, the bought sense that I got from that was that if there is a situation where it has to be interpreted, and even as much as I look at it and say, this is the dumbest thing I've ever seen, how could you charge him with menacing and robbery when he's the one that actually calls 911? You have clearly the criminal here that has already been arrested. How do you release him and arrest my client that is maybe overzealous in trying to get his money back, but certainly hasn't committed a crime? But I learned that if you have to make the call on whether it's going to be if there's an interpretation that has to be made, qualified immunity is going to be there for the officers. So you want to make sure that you look at your cases carefully as you select your cases. And that brings us to how do you overcome, part of the title here again is overcoming immunity challenges. As far as we talked about absolute immunity, not a whole lot you can do about that unless you have a situation where the prosecutor, judge, or magistrate is operating outside of their official capacity functions. But as far as qualified immunity go, I'm going to give you just a few things that have worked for me. Hopefully you won't have to buy some of the sense that I had to buy. So the first thing is to start with your theory of the case. I heard my law partner, Chris Burrell, talking earlier about theories. Though it's very important because it directs your activities. The sooner the better. I usually start drafting the theory after the first meeting with my client. And when I say a theory, I mean, what are the facts that we're alleging? What are we trying to prove happened? What's our story? And then I haven't talked to the defense. I haven't heard anything from them. All I have is my client's story. So I will still write out one from their perspective, because everything that I do in litigation needs to be directed towards either forwarding my client's interest or undermining the defendant's case. So you can waste a lot of time if you don't have a theory, something that's directing and driving you. You could be off down a lot of rabbit trails. With a theory, with a solid theory, and it evolves over the case. You can find out things in discovery that will change, that can cause your theory to evolve. But if you don't start out with one, you'll chase down things that neither help your case nor undermine your client's case. So they're nothing. They mean nothing to your case. They don't help you at all. So you start off with a theory. And that theory, while you're looking at the theory, part of it has to be part of what their theory is. In pretty much every case that I have, I know that their theory is going to be that there was qualified immunity. Because most of the time, you're not going to have a situation, especially when you're dealing in police misconduct, like I do, where the officer is saying, I totally did nothing. I didn't do anything to your client. Usually they're saying, yeah, we did that, but we were justified. The force was reasonable. The arrest, we had arguable probable cause, even if it turned out to be completely erroneous. At the time, we believed this. And on a side note, there is the best cases in my experience have been the cases where the officer is actually claiming that the officer is claiming himself or herself that the person did something. Because what happens if the officer has a witness, it's going to be hard for you to prove or to get past to say that they didn't have arguable probable cause when they say, I relied on witness such and such, and I believe that they were telling the truth, which they always will if that situation comes up. So that includes the qualified immunity claim. So I'm always looking for, okay, how are they going to try to get qualified immunity? The qualified immunity, one of the things, going back to the definition of it, is you get it if it's a discretionary function. If you have a case where the officer has made an arrest, committed some force, usually in furtherance of making an arrest or keeping control in a prison or in a jail, what have you, you are going to, that part is going to be, everybody's usually going to stipulate that they were performing some discretionary function. Because since they have the right to use force, reasonable force, that use of force is a discretionary function. Making an arrest is a discretionary function. So that part is going to be met. The clear constitutional, unless they have violated a clear constitutional right, that can get tricky sometimes, because you can occasionally have a situation where the officer has done something that's so wild that there's not any case law on it yet. They will make the argument that, and ironically sometimes, that this was so bad that we hadn't ever seen it before. So he couldn't have been clearly violating a constitutional right because we hadn't seen it done like this before. But the catch for the officer is that if a reasonable person would have known that this is clearly beyond the pale, you still could have qualified immunity stripped from them. So next, so you have your theory. We're talking about trying to overcome the challenges of immunity. Next, as you're drafting your complaint, and I heard Judge Johnson talk about this earlier as well, as you're drafting complaints, it is not only within the rules that you that you draft with one fact per count per paragraph. It is advantageous to you as a plaintiff's lawyer, because you want to know when the defense lawyers send back the answer that says, we deny everything, and then we have 1,000 affirmative defenses at the end. If you haven't alleged one fact per paragraph, you don't know what they've denied. You don't know what they've admitted. Usually it's hardly anything besides the fact that the plaintiff is a person and the defendant is a person. But so you don't know those things, and you can't. I have gotten some of the best mileage out of answers to complaints when everything is denied, when I go over the answer with the defendant in deposition, because it takes them off balance, because one, usually they don't know that everything has been denied, but because the lawyer did it. So as you're going through it, You said, do you really deny this? There's one case where I had an officer actually, before he got when he got the complaint, somehow the complaint got to him when I served the sheriff's department. They gave it to him, whoever received it gave it to him, and instead of him sending it to his supervisor, which would have sent it to the insurance company and then they would have sent it to the defense lawyer, he took it upon himself to answer the complaint. And he answered it himself, and it came back. He filed it and everything, and then the lawyer came back in. The defense lawyer came later and made the official answer, but I already had his answer. So everything I did request for admissions. I did request for admissions, and every request for admissions was something that had come out of the answer, the original answer, the pre-lawyer answer. So the request for admissions all come back denied because the lawyer took them and denied the request for admission. So when I got to deposition, I went over every denial, and the lawyer finally had to say, well, he didn't answer those, I answered those. And that's a problem. You shouldn't be doing that. No one wants the lawyer's answers. We want your client's answers. We want the defendant's answers. So draft your complaint in a way that attempts, if you can, to foreclose upon qualified immunity. And I almost skipped a step on overcoming immunity challenge. Case selection. Know your craft. Know what the state of the law is. Know what the new cases are that are coming out of the Supreme Court. And for us in Alabama, if you're in Alabama, Florida, or Georgia, what's coming out of the 11th Circuit. So you can select cases that are not, there are some cases you can look and say, well, this is surely, they're going to get qualified immunity. And you can sift through and know which ones are worth fighting, or knowing, okay, well, this is going to be a slam dunk on qualified immunity. So that's your first line of defense in overcoming immunity, is selecting the right cases, which is probably every area of law as it comes to litigation. Selecting the right cases saves you a lot of headache down the road, time and money and energy. Next, so we've talked about the complaint. We've talked about selecting your case and drafting the complaint. Do a thorough job in written discovery. You want to find out what kind of training the officer had, what kind of, up in North Alabama, I found a lot of times that they have training. Their training includes testing on constitutional amendments, Fourth Amendment, what qualified immunity is. So the officers are tested. They study and test on these things. So I've gotten to go in and ask questions that would normally be clear objections or objectionable based on calling for legal conclusions, but I'm just going through the discovery. And the officer is signed off saying he understands these things. He's answered them correctly. He knows what the Fourth Amendment protects against. He knows what excessive force is. So usually without those things, if you haven't done that, you don't have those documents in hand. If you ask those same questions, you have the defense lawyer directing his client not to answer because it calls for a legal conclusion. But we're not talking about legal conclusion. We're talking about discovery. We're talking about the documents that were given to me. So if you do a thorough job there, and that prepares you for, and with your interrogatories, requests for productions, as well as requests for admissions. I would always do requests for admissions because that is you're not only looking towards trial, but in order to even get to trial, you're going to have to go through a motion for summary judgment usually. So your request for production, your request for admissions especially, can be helpful in setting up those genuine issues of material facts. So you want to set up those factual disputes. I'll even take it a step further in deposition and ask things that I've gotten from discovery and that I already know when I come into the deposition, or that I know that they're going to deny. And I'll say it blatantly, like, okay, well, you say this, and my client says this. If my client says this, would you dispute that? Yes. That would be a factual dispute. Yes. This fact is pretty important. Yes. So I go through and lay a foundation. So when we get to, I use their deposition against them in summary judgment. It's like, okay, we have a lot of genuine issues of material factual disputes here. That's going to be hard for you to get your summary judgment granted or get your qualified immunity, which is usually going to be the vehicle that summary judgment is granted under. That's the next thing is prepare for your depositions. Same thing, using that discovery, using discovery and being well versed in the discovery, reading the documents that they send to you. I've heard plaintiffs' lawyers say, oh, they document dumped me. They sent me everything. And they sometimes bemoan that. But it can be a positive thing. I don't mind that they send me a lot of documents, because what they're counting on usually, in my opinion, is that you won't read those documents. Well, I read every single page of the documents, and they're counting on you not reading it because usually they haven't read it. So there are things in there they may not have sent you had they known they're there. So go through those things and make sure you have a system of cataloging. I'd have a system of processing discovery to where I know exactly what page everything is on. Everything is based on whether they send it based stamp or not, but usually the defense does. I know page, paragraph, every important fact that I need in deposition. I can go to it easily, and it lessens your work if you have to go to trial as well. And you may also need for immunity, depending on how close a call it is. And so a lot of times with 1983 cases, you're going to have situations where it's unreasonable. You have someone that is shot with handcuffs on. A layperson knows that that's not what should be happening. You don't need an expert witness to say that, but if it's a closer call, you may need a police expert witness on police standards or guidelines to get past that hurdle. That's all I have. I thank you, Chris, for having me. I don't know if we have any questions or anything like that. Yeah.
Hey, Terrell, thanks, man. Really appreciate it. You did a great job, especially under the circumstances. Unfortunately, we found out late yesterday that Fu was sick. And Terrell is at least the second or third best civil rights attorney that I know. And I asked him if he would step in, and he stepped in grand fashion to save the day. So it's kind of funny. It feels like we're at the Burrell McCants recording studio now, because I'm in my office on Zoom. Our assistant is in another office on Zoom. She's also serving as our producer. And then, of course, Terrell's in the conference room. So it was great. Let me, I'm going to check around. If anyone has any questions, you can use the Q&A function, or you can also use the chat function. I see that there's some comments in the chat section, so I'll go ahead and look at those real quick. Henry Pennick asked, Section 1983 requires a constitutional violation which require intentional conduct. Alabama state law makes a governmental entity liable only for negligent acts. How can a Section 1983 plaintiff keep the governmental agency liable in a 1983 case?
Okay. In a Section 1983 case, you can keep the government entity liable through a case called Monell. We call them Monell cases because it's municipal liability essentially, where you have to show a custom policy or practice, and that usually is done through discovery. You find out, because usually you're going to need you got to get the cities, and usually we're talking about cities or counties. You get their policies and procedures, or if you have someone that has made a decision, that has ratified, that has final decision-making final policy making decision power in a case that's high enough up, they can actually serve as a kind of a proxy for making the municipal entity liable. And as well, a constitutional violation doesn't, usually you are talking about intentional conduct by an officer, but you can also, I believe it's, I can't think of the code section now, but I believe it's a 47- something, but it's municipal liability, where if you show that the behavior or the conduct of the government entity's agent is unreasonable, is unskillful, careless, or has shown neglect, usually we can do those. I plead those in because excessive force, though it's intentional, there's also an argument to be made that it is unskillful. One of the skills that police officers are to have presumably obtained is the ability to understand what is reasonable force and what is not, and the ability to ascertain whether they have probable cause. So if they make a false arrest or commit excessive force, there's an argument there that behavior was not only intentional, but it was unskillful. So that's another avenue to keep the government entity in.
All right, thank you, Terrell. I appreciate that response. I'm sure Mr. Pennick does as well. I'm looking to see if there are any other questions. We still have a few minutes left. It's 2:52 right now. So if anyone has any other questions, go ahead and drop them now. I'll forever hold your peace. And I was kidding about Terrell being the second or third best civil rights attorney. I know he's absolutely one of the best. And pardon me if I have a selfish interest in saying that, but yeah, he really is one of the best. Okay, well, at this time, I don't see any other questions. So what I'll do is I think we'll go ahead and end. But before we go, I do want to remind everyone, first and foremost, that you should definitely provide feedback so that you can so that you can receive credit for attending the CLE virtually. Secondly, we want to remind everyone about the Magic City Bar's annual meeting. It will be this afternoon at 6 o'clock. And thirdly, if you have not already renewed your membership, go ahead and take a moment to do that today. Your membership will renew for the 2021 year. So go ahead and knock it out the way now before you spend all your money on Christmas. But if there's nothing else, I think we'll go ahead and end now. I want to thank everyone for being here. Thank you, Terrell, once again for pitching in. And I want to send a special shout out to our good friend, DeAndre DeBross. Hope you get to feeling better soon, DeAndre.
Soon, Fu.
Thanks, everybody, for being here. Y'all have a great day.